Did they meet the burden of proof on each charge beyond a reasonable doubt? That will be the question. So let's bring in criminal defense attorney Sara Azari. And Sara, let's start with the highest charge here, which is second-degree unintentional murder. Do you think the prosecution proved their case on this?
Well, Brianna, first of all, it's great to be with you, and congratulations to both of you on the new day. Look, we have one universe of conduct, but this shotgun approach of three alternative homicide counts, the distinction between them, as Laura explained, being intent. And the use of force evidence that we heard and saw and the causation evidence support all three of these counts. I didn't think I would ever say this with conviction, but the prosecution has met its burden of proof beyond a reasonable doubt. The jurors may not agree with me. I'll get to that in a minute. But here with the second-degree murder charge, this is the felony murder rule in Minnesota. So the evidence we heard from 5 Minnesota officers, Chauvin's boss, the officer who trained him, the police chief, which is rare to see in these cases, and a law professor who all consistently testified that the use of force was not only excessive and unjustified, but also against department protocol and against or contrary to Chauvin's own training. So without the lawful use of force, you have an unlawful felony assault. And then you get to the causation, that substantial causal factor. We heard from a cardiologist and a renowned pulmonologist who both said that he died of hypoxia. Not all this noise about the pills in his system, the tumor, the enlarged heart, the fugazi, carbon monoxide stuff that had no supporting evidence, but really that Chauvin's knee to his airway was what caused the lack of oxygen. Then we get to third-degree murder. So I believe second-degree murder is met. We get to third-degree murder, which is this depraved heart murder. And the prosecution, I believe, has proven that Chauvin committed a reckless act that is imminently dangerous to Floyd with a depraved heart, that's a really ugly heart, and disregard for his life. All that evidence that we saw about his failure to render aid to Chauvin goes to this very issue. We heard from bystanders, we heard from an off-duty firefighter, we heard from medical experts. In fact, the defense's own expert, Dr. Fowler, on cross-examination gave the prosecution the gift of, yeah, Chauvin should have, but failed to render aid to Floyd. So this count has also been met. And let's not forget Blackwell's last words to the jury were that Floyd did not die of his enlarged heart. He died of Chauvin's small heart. Boom, depraved heart right there. Then we get to the second-degree manslaughter, which, on its face, it looks like a blind dog could convict Chauvin on this count. But it's a little murky because a few months back, the Judge Cahill, was not going to allow this count in because of the term others in the statute. This is that Chauvin acted with culpable negligence where he created an unreasonable risk to others and consciously took the chance of causing death or great bodily injury. And so this term others, the judge thought was confusing. It went to the appellate court, then the judge got reversed, and it made its way into the case at trial. But much like the judge thought this might be confusing, one or more jurors might think that this is, others, meaning other than Floyd, perhaps. So that is sort of a murky thing with last count. But the bottom line is that it takes one stray juror, even if unreasonable, to believe that there's doubt in this case and hold out, and then we have a hung jury and we have a mistrial, which is the best that the defense could ask for here.
Sara Azari, thank you so much for your analysis. Really appreciate it. Let's talk about the defense. Derek Chauvin's defense argued that he acted reasonably.